Everyone, I am Rusha Mukherjee, a student of Surendranath Law College and a present intern at LSE. Today, I am going to talk about the mistake of law and a mistake of fact. Now, the mistake and ignorance are two terms that was coined quite long ago and is very hard to distinguish. The mistake of fact and the mistake of law has been coming from the two common law principles, ignorantia facti excusat and ignorantia juris non excusat, meaning mistake of fact is excusable, but mistake of law, no, that is not excusable. Why? Because the person who does not know or is not well adversed about his situations cannot possess the actual intention of or the intention of crime or the mens rea to commit the crime. His intentions are obviously bona fide. On the other hand, a person or the mistake of law cannot be excused however genuine reasons he may be having. Because of the reason, if mistake of law is being excused, then each and every criminal will be telling that they are ignorant of the law in that sphere. And it will be very difficult for the prosecutor to prove that they are well cognizant with the law. And hence, the law states, the IPC states that ignorance of law is never excusable, but if we are not aware of the facts, then it is obviously excusable. Section 76 to Section 79 of the IPC deals with the provisions relating to mistake of fact and mistake of law. Section 76 of the IPC states that if any person is bound by law to do something or believes himself under the mistake of fact that he is bound by law, is not punishable. He cannot be held liable under the IPC. We can take an illustration. If a police officer shoots a mob or fires a mob under the instruction of his senior, he can never be charged for it because he is doing it under law and he is bound by law to do it. Certain case laws are taken for this mistake of fact. The first case law is R versus Tolson, wherein the wife married for the second time. But the case stated that Mrs. Tolson actually married for the second time after she was completely convinced about the death of her first husband in a ship that has been drowned. All the relatives and all other friends had informed her that her first husband was dead, and then only she married for the second time. She was not charged of bigamy because she had no intention of committing the crime of bigamy and was only under a mistake of fact. In the case of Rosie, it has been told that homicide under the influence of mistake of fact is excusable. In that case, the boy believed that his father was actually going to murder his mother, and so he had committed the murder of his father. In this case, he was not held liable by the court because he did not do it intentionally, but actually because of the mistake of fact that he believed his father was attempting to murder or kill his mother. Section 77 and Section 78 actually protects the government sector. Section 78 is a corollary to Section 77. Section 77 protects the judges. If he has done something during the discharge of his official duty, if he has done it in good faith or a bona fide faith, and if he is in his own territory. Section 79 is actually very much related or very much close to Section 76 of the IPC. Section 79 says, if any person does an act, the act being justified by law, or if he believes by way of mistake of fact that he is justified by law to do that act, he is exempted from any punishment. In this case, we can take an example. If A takes B to the police custody, believing that B was actually committing murder or trying to commit a murder, he is not guilty of wrongful confinement, even if he was under a mistake of fact and he was actually doing something which is wrong under the law. The circumstances may reveal that the person who was being taken to the police station was acting in act of self-defense and not committing any murder. But still, the person acting, believing himself to be justified by law, cannot be punished for that. Section 76 and 79, main difference is that Section 76 talks about the people who are bound by law or thinks himself to be bound by law because of a mistake of fact, whereas Section 79 talks about the cases where the person is justified by law or thinks himself to be justified by law. And the purpose of Section 77 and 78 is that the judges should be able to perform their duties, their legal duties or their official duties without any hesitation or without any fear of being prosecuted for their act. The judges and the other government officials or judicial officials are exempted from prosecution under the Judicial Officers Protection Act from civil liability also. So, in a very short crisp, we can say that if we don't know the fact, if we are ignorant of the fact, we can be excused. But not knowing the law, ignorance of the law, being unaware of the law, or claiming not knowing the law of the land is never ever excusable. For example, if a police officer is arresting someone because he doesn't know that whether the offense is a cognizable one or a non-cognizable one, and believing the offense to be a cognizable one, he arrests someone, he will never be excused by law and he will be liable and prosecuted under the law. But if he arrests someone believing him to be someone else in whose name the arrest warrant has been issued, and believing the person to be that person, arrest him, he is not liable to any criminal prosecution. This is a very basic difference between mistake of fact and mistake of law and its use in the Indian Penal Code or any criminal code. Thank you.